today is University of Akron versus Felisha, Rushin. Only the University of Akron will be arguing today, so I don't need to talk to you about reserving any time for rebuttal. The arguments are being visually and audibly recorded to be posted online. Please keep your voice up. You can go ahead and take the podium, and please remain behind the podium. We've read your brief, and we are ready to begin when you are.
Thank you, Your Honors. May it please the Court, my name is Sue Kresnicki, and I represent the University of Akron, care of the state of Ohio. I filed the notice of appeal and, of course, my appellate brief in this matter. I did not file a reply brief because the appellate brief was stricken from the record. So all we have is my appellate brief for this matter. I'm just going to, I believe that my brief addressed all the issues. I'm going to just reiterate a couple of issues, and if you have any questions, obviously, please feel free to ask me. In the lower court, this matter went before the magistrate for a garnishment hearing. And at that point, the University of Akron, care of the state of Ohio, had already taken judgment against Ms. Rushin. And so this was simply a garnishment hearing that was going forward. Excuse me. At that garnishment hearing, the lower court ended up determining that the debt was discharged and attempted to dismiss the case. Actually entered an entry dismissing the case. And
was the court presented with an order of discharge from the bankruptcy court?
I don't believe so. I think whatever they were presented from the record, the transcript of the hearing was sent to the Court of Appeals. And I think that was presented was what Ms. Rushin presented, which was it was an order of discharge, but there's several pages to the order of discharge. And the second page of that order of discharge, which was part of the record, specifically addresses the fact that there are debts part of her bankruptcy that were not discharged. And so the argument to the lower court was that this was a student loan debt. It was not discharged. And the lower court doesn't have the authority, especially not at a garnishment hearing, to determine dischargeability. So it was a garnishment hearing. At that point, if there was an issue as to the debt, then the garnishment should have just been dismissed at that point. The lower court attempted to also dismiss the case, even though they couldn't dismiss the case, there was already a judgment pending, or a judgment, the case had already been adjudicated. So the objection to the magistrate's decision was filed, and the judge did determine that the case couldn't be dismissed. So the judgment remains, but affirmed the magistrate's decision that the debt was discharged, which it wasn't discharged. It was student loan debt.
Well, I know student, and normally they're not dischargeable.
Right.
But there are exceptions to that rule.
There are, but the only way you can get a student loan discharged is if you file an adversary proceeding in the bankruptcy, and you have to, there's a whole test that has to be met.
I'm familiar with that process. That's why I asked, was there anything before the court to indicate that that actually happened in the bankruptcy?
It did not happen. It was a Chapter 7 no asset bankruptcy. So therefore, there was nothing done in the bankruptcy because there were no assets.
Okay.
So had Ms. Rushin wanted to have that student loan officially deemed discharged, which she may have been able to meet the requirements. We don't know because she never filed an adversary proceeding. So that would have been her next step. And that may still happen if this court reverses the magistrate's decision, or the lower court's judge's decision affirming the magistrate's decision. She could go back into the bankruptcy and try to get it discharged. But at this point, this debt is not discharged. And the magistrate took a garnishment hearing and deemed a debt that the bankruptcy court hasn't even deemed discharged. So that's what we're asking for, is for the lower court's judgment to be reversed, for the judgment to remain in effect, and for the dischargeability order to be reversed and off the record. And then we could proceed with another garnishment, and at that time, Ms. Rushin wants to try to go back into the bankruptcy court. That would be her prerogative to do so. But the lower court does not have the authority to deem this debt discharged. I mean, specifically what was presented to the court even said, some debts are not discharged, and student loans are one of them. Just to reiterate a couple other points, just what's on the record, the state of Ohio did file an appearance in the bankruptcy, so we were part of the bankruptcy. I believe the lower court in one of its decisions said the state of Ohio didn't participate in the bankruptcy, which is not true. We did, but it was a no asset. There was nothing to do at that point.
a claim was filed in bankruptcy.
Well, no claim was filed because there was no asset. It was,
So just a notification.
right, so that we would get notifications of bankruptcy proceedings. And I believe that's all I have to present, Mayor. My brief speaks for itself. If there are any further questions.
All right,
Okay,
thank you for your time.
Thank
and
you.
your argument. We will take that under advisement, issue a written decision in due course.
okay, thank you very much.